joining us now. I don't really need to give him that much of an introduction. He's one of the very few people of legal distinction who is a national name, Alan Dershowitz, we were just actually talking about how many books he's written. 50 books. His newest book, The Price of Principle. There it is. Why Integrity is Worth the Consequences. And as you know, Mr. Dershowitz is a professor at Harvard Law School. He's been there 50 years, now emeritus, and he's been all over this. He's got a great piece that's out in the Hill that gives a lot of insight into this as well. Good to see you. Thank you so much for joining me. The big, I think, missing piece in all of this, and I wanted to get you to give us your expert perspective on this. The Rosetta Stone is this warrant. We don't know what any of the details in the warrant or the application. We don't even know actually if Trump's folks say they don't have it. Eric Trump was telling the press that they just merely showed it to the attorney. They don't know the idea of the contents. We also seen reports that apparently it was sealed, which the way that I understand, I guess you have to have a court order to unseal it. So he doesn't have it. Even if he did have it, it's sealed. So tell us a little bit about this and who should release it and how do we go about that?
It's a very good question. Generally, the warrant itself is open to the public. The affidavit is usually sealed, allegedly for the protection of the person searched. And so one thing Trump could do is have his lawyers go to court and say, we want everything unsealed. The public has the right to know, and we waive whatever right to privacy there is. Now, I don't know whether or not former President Trump wants to do that, and the court won't necessarily grant his request. But it increases the chances of getting not only the warrant, which will be gotten. The warrant is a public document. It should be available. It's the affidavit in support of the warrant. Remember, the warrant is a form, usually signed by judges the way parents give out Halloween candy. There's almost no discretion involved. Judges rarely turn down requests. But it's the affidavit that's the key. And nobody should be blaming this judge. This judge is being attacked. Judges grant search warrants all the time. The critical comment should be directed at the Attorney General of the United States, the head of the FBI. They have to get on television, have a press conference, and have excellent journalists like you ask them the hard questions. Why didn't they go for a subpoena? They knew the boxes were in the basement. They knew how many there were. They knew the president was 1,000 miles away. Why not issue a subpoena saying, bring these boxes sealed to the court tomorrow? The judge will go through them. He'll decide what was never classified, what was declassified, what was privileged under executive privilege, lawyer-client privilege. He'll ask the client whether he wants to invoke production, Fifth Amendment issues. That's the rational way to do it instead of doing what happened to the congressman and doing what happened to the former president. That's what happened with Hillary Clinton. That's what happened with Sandy Berger when comparable allegations were made. Nobody conducted searches. Nobody had investigations. Berger was fine, and Hillary Clinton was rebuked, may of course, to the presidency, but nothing legal.
Right.
And that's what should happen. And, you know, there's this new argument out there. It's called whataboutism.
Yeah.
Well, it's a very important argument, whataboutism. What about Hillary Clinton? She's now wearing a hat that says, but my emails. That's not appropriate. Her emails are very comparable to what is being sought in this search. So we're entitled to ask that question.
And it's a fantastic question, talking with Alan Dershowitz about this whole case. And you mentioned, too, they already knew the boxes were in the basement. They were already there. That's what the timeline on this. And I get the sense, it seems like, and tell me if you agree, that the DOJ is kind of leaking some information. It seems like they're really trying to absolve Merrick Garland of having any knowledge of this and throwing Chris Wray under the bus. Is that what you're getting? I saw this piece in Newsweek where they had some source who has knowledge of everything. And he was saying, oh, Merrick Garland had no idea that this is all Christopher Wray. Do you buy that?
No, I don't. It'd be inconceivable for the Attorney General of the United States not to sign off on the search of a former president's house. Look, this is all about what's happening in America. I write about this extensively in my book. Nobody cares about principle anymore. Nobody cares about the Constitution. It's due process for me, but not for thee. You have to pick sides. You're a partisan. If you're a partisan Democrat, then this is the greatest thing that ever happened. If you're a partisan Republican, then Trump did no wrong. What about if you're like 80% of Americans, neutral, nonpartisan? We prefer one party to the other. I'm a liberal Democrat. You may be a conservative, but we admire each other. We talk to each other. But the vast majority of Americans want to see operation under the rule of law. We don't want to see the weaponization of the criminal justice system, either for the Democrats or the Republicans. Every civil libertarian should be outraged at what happened in Mar-a-Lago. They should be outraged at what happened to Paul Manafort, to what happened to Navarro, what happened to Stone. These people shouldn't have been arrested. Their lawyers should have gotten a call like I get all the time from the U.S. attorney saying, your client's been arrested. Could you bring him in on Tuesday? Oh, no, that's not convenient. We'll bring him in on Wednesday. We'll present him to the magistrate. He'll be out on bail. Then we'll have our trial. That's the way it works. Subpoenas instead of search warrants, calls to the lawyer instead of arrests. But something has changed. Something has changed. Principle is out the window. Partisanship prevails.
I love this point, and I agree with you 1,000% on this. I'm looking forward to reading your book, The Price of Principle: Why Integrity is Worth the Consequences. Explain to us the legality of this. My favorite time of any kind of breaking news story is everyone on social media pretending to be an attorney, and everyone gives you their opinions. The showing of the warrant entering Mar-a-Lago, it just seems weird to me that the attorneys weren't allowed to be there. They wanted them to shut off the security cameras. Is that normal?
Well, it's normal, but it's not proper, and it should change. And one thing about these new developments, it's turning a lot of conservatives into civil libertarians. We have to change the law. Every search should be videotaped. Every time there's a search, the lawyers ought to be allowed to go and watch the search. What does the FBI have to hide? Why are they afraid of lawyers watching this? You know what's going to happen now. Now, if they find anything, people are going to suspect that it was planted. If you had a videotape, if you had lawyers there, that suspicion wouldn't occur. Justice must not only be done, it must seem to be done, particularly during these divided times where everybody's on a side. And there was no reason to throw the lawyers out. Of course, he should have gotten a copy of the search warrant, and he should have gotten a copy of the affidavit as well, maybe with a name of an informant redacted or a name of some secret redacted, but there's no reason to keep everything away from the public. We live in a transparent democracy. We're supposed to be able to judge who is going to guard the guardians. We're the ones who are supposed to guard the guardians. We know the courts aren't doing it. They're issuing search warrants like candy. But we, the media, we're entitled to oversee what's going on and to present it to the public for criticism. Absolutely.
Talking with Alan Dershowitz, whose new book, The Price of Principle, is out now and available where books are sold. The moment from, I think it was the CNN or ABC piece, where they were discussing how they had all met. They took them on a tour, I guess, of where all the records were stored at Mar-a-Lago. You go from that to having the raid. The source that was written about in Newsweek that was apparently leaking information was saying that they waited specifically for Trump to be out of town because they wanted to keep it low profile. And they thought this was the way, he's shaking his head, this is the way to do it.
If you believe that, I have a bridge to sell you in Brooklyn. Low profile, come on. You think you're going to have a search of the president's house, former president's house, and it'll be low profile? Who's advising these guys? Do they not understand the America we live in today? They wanted him out of the house because they didn't want him to be in any way interfering or calling his lawyers or doing things like that. They often do that. Sometimes they arrange to search a person, to arrest a person, in order to do a search of the person. That didn't happen here. They weren't interested in searching the body of Donald Trump. They were interested in searching his wife's closet for her clothing. The other thing a search warrant does is it allows you to pick up anything as long as it's in plain view. You don't have to comply with the specific words of the warrant, even though in the Constitution it says warrant shall not issue except upon probable cause. And then it requires it to be specific. But once you have the warrant, you can pick up anything. Whereas a subpoena, it requires you to turn over only particular documents, which the judges then have to examine if a defendant raises questions to it. That's why they wanted the search. That's why they didn't want to have a subpoena. They didn't want him to invoke privileges. And look, yesterday he invoked the Fifth Amendment.
Yeah.
That validates the point that I made in the Hill article, that the reason they did this, and in another article in Newsweek, the reason they did this is to circumvent his rights under the Fifth Amendment, under the Sixth Amendment, etc.
That's a great point, too. And this also calls into question why they brought a safe cracker, because apparently, what the contents of the safe, which apparently was empty, that's not in plain view. So clearly there had to be some specificity for that.
There better be. And, it reminds me of Geraldo Rivera with all the publicity about going into Al Capone's safe. Yes. Everybody was watching and it was empty. The same thing was true here. You could easily subpoena a safe as well and ask the safe to be brought over to the court. If it's a wall safe, obviously, that's a different matter. But still, you don't have to search it unless you have a reasonable basis, probable cause basis for believing there was something in that safe, which was evidence of a crime. And I don't know what they were thinking about and what they told the judge and what the judge believed. The other thing I'm very mad at, though, is people on the right attacking the judge, saying, oh, my God, what a terrible man he is. He actually represented Jeffrey Epstein's secretary. Well, I represented Jeffrey Epstein. You don't judge a lawyer by his or her client. You don't judge a judge by who their clients was back then. You can be critical enough about the judge and what he did. Maybe he wasn't scrupulous enough, but don't bring Epstein into this. That's just McCarthyism.
Yeah, there were some people who were, I saw this circulated, a PDF of, it was a civil case between Hillary Clinton and Donald Trump, which he recused himself from. And a lot of people were wondering, well, why would he recuse himself from that but feel comfortable signing off on this? Is there...
That's an interesting question. Yeah.
Yeah, because we saw that, and I thought that's a little odd if he would recuse himself from this, but then he would sign off on the warrant. And I guess we have to wait for the warrant before we can get some more answers for that. But that's a very, wouldn't that reason that he recused himself from the civil case also apply to him with this warrant?
Probably, unless he recused himself because of some connection to Hillary Clinton, who wasn't involved in this, but it wouldn't matter.
Right.
Judges grant warrants. If he turned it down, they just go to another judge and another judge and another judge. Warrant protection is hollow today. It doesn't really guard the guardians.
That's a good point. Which brings us to the Scott Perry case. What do you make of this? They went for his personal, not business, I would imagine, congressional phone.
I don't know. You couldn't go for the congressional phone because the congressional privilege would probably protect that. But he's also very protected by that privilege. Not completely. You can indict or investigate a congressman for corruption, but not for what they say or do on the floor of the House or on the floor of the Senate if it's a senator. So I don't think we know yet enough about it. And the question is, again, why not a subpoena?
Right.
You can't erase things from phones. Everything is permanent these days. There are people in the FBI who can dig out any metadata from phones. So a subpoena would do just as well. And the idea of confronting him in front of his family, in a public place, seems designed more to intimidate than to obtain relevant information.
Yeah, that's a very good point. Alan Dershowitz, the book is The Price of Principle, Why Integrity is Worth the Consequences. We really appreciate your expertise on this. Thank you so much for joining us today. It's good to talk with you.
Thank you.
Of course, take care.